So my name is Goodey. I'm head of the Justice, Digital and Migration Unit at the European Union Agency for Fundamental Rights, which is based in Vienna. And I've titled my talk today, Fairness, AI and Fundamental Rights, because of course I'm coming from the Fundamental Rights Agency, so you'd expect me to talk about fundamental rights. But very much in the language of how lawyers think about it, they tend not to think about fairness. They think about, I already saw the words up there, of course, non-discrimination and equality, for example. So in my talk today, and I was quite surprised when I was told you have 40 minutes to speak. I'm not used to this anymore. I'm used to giving like 10-minute quick policy feeds, so I nearly fell off my seat when they said you've got 40 minutes. This was like going back to being a university lecturer, which I did many, many years ago. But anyway, I'm going to introduce very briefly the Fundamental Rights Agency. I don't know if you know about us, but just to say what we are very briefly. And then I'm going to focus on EU policy making on AI from a fundamental rights perspective. I'm going to then point to some findings from FRA research that we've done, bias in algorithms, feedback loops, online content moderation, and specific use cases. The professor who just introduced this workshop said they were working, I think, since the 1980s. We only started around 2016, and we're not tech people. So that's to put it in context. And then I'm going to be talking about the ways forward. So very briefly about the Fundamental Rights Agency. So we're an agency of the European Union, like Frontex, the border agency, like Europol, the police agency. And we're centrally funded by the EU. We're based in Vienna, and at the heart of what we do is to look at the situation of fundamental rights in the European Union, in all 27 member states, and the accession countries to the EU. So we consist of lawyers, social scientists, statisticians, which is very important if you're working on AI. I have one person who can actually program, which is a rare thing in a human rights-based setting. But we work a lot with technicians and computer scientists. We've begun to do that increasingly. We report to the European Commission, European Council, that's the member states, European Parliament, and the member states about our research. It informs the development of law and policy in the EU. So we're very much there in those discussions about the formulation of law and policy. So to move on about EU policy making on AI, to put the work of the Fundamental Rights Agency and your work in context. So as I said, I'm beginning relatively recently when we talk about AI. And what I've put on this slide here, you can see when the EU institutions began to wake up to the realities of AI. And I've just picked this date here. I could have gone a bit back in time, but 2017, there were resolutions on robotics and big data. Everybody was worried about self-driving cars. We know that. It seems a bit now like in the ancient past that all we were obsessed by, at least in the public's perception of AI, was the self-driving car. Then the European Council got involved with conclusions. But then in 2018, the European Commission, which of course is responsible for drafting law, and we'll come to the AI Act in a bit, got very active. They had a communication on AI for Europe, a high-level expert group on AI. So I was a member of that high-level group on AI, one of the few persons who were coming at it from a fundamental rights, human rights perspective. Mostly it was people from industry there, from academia, civil society, who also came with a human rights lens, particularly in relation to privacy and non-discrimination. And then you saw European countries joining forces about AI, all in the same period then. Then things got even more interesting. The EU published a white paper on AI. Now, the words excellent and trust came in, and the notion of human-centric AI came in. people weren't necessarily always talking about non-discrimination and equality. So we're talking about AI for good as well, but what does that actually mean? Where we're at now, and what everybody's excited about, and the media is picking up on all the time, is the fact that, of course, back in 2021, the Commission proposed the AI Act, and it was formally adopted only last week in the European Parliament, and the final formal adoption should be in April. So it's happening. But if you've been in those discussions back in 2017, most people were saying, self-regulation is okay. Do we really need an AI Act? But what was interesting, I think, in the discussions in the high-level group I took part in, is that when I gave examples, is that we regulate chemicals. We have a whole EU agency for chemical regulation. We have the European Centre for Disease Control. We have the European Medicines Agency, which is all highly regulating things that can do good, but can also do harm. But still, the discourse from industry at the time was very much, we don't need that. And you know also where it's coming from because of the US-based companies' concerns and other concerns in that regard. Also of relevance, but I don't have the time to speak about that, is the Digital Services Act. And that's something that we separately work on, which also engages AI. Now, hopefully, you've had a go at looking at the AI Act, because it will become very real for those developing AI and deploying AI and working with business. As I said, we're awaiting the imminent formal adoption of it, but of course it tackles AI through a risk-based approach, really about consumer protection, product protection ideas. That's where it's coming from. From prohibited AI, social scoring, to live use of facial recognition technology. I say live because there are many caveats and exceptions in the current draft, to high-risk AI that can do harm to humans if not sufficiently scrutinised, limited risk and minimal risk. And of course AI, it can range, as you know, from everything to do with use in agriculture, which might seem pretty benign, it has little impact on humans, one could theoretically pose, through to the kind of AI used in medicine and other fields, which is high risk. Interestingly, when we first looked at the draft of the AI Act, we said, well, where are deep fakes? There was very little concern about deep fakes, and that's increasingly got attention now. But deep fakes really are not up there in terms of being perceived as very high risk, which we know is highly problematic in terms of democracy and safety of the individual. And then, of course, the discussion about general purpose AI models with systemic risk, they now come under high risk, but consideration of those areas came in very late in the day, which is somewhat surprising. So to go back to the title of this conference was about fairness. As I said, legal experts tend not to talk about fairness. They don't. They talk about non-discrimination. When you look at the draft text of the Artificial Intelligence Act, it's talking about discrimination, non-discrimination, because it's the terms that lawyers typically use, and equality to some extent. There might be reference to things like fair working conditions and things like that. If you look at the Act as it currently stands, Article 11 of the Act, and don't worry, I'm not going to give you slides and slides and slides referring to articles, because that's the last thing you need. But very, very briefly, Article 11 in the current Act says that providers of high-risk systems have to draw up technical documentation before the system is placed on the market to include metrics to measure accuracy, potentially discriminatory impacts, and also a description of sources of risks to health and safety, fundamental rights and discrimination. And then Article 10(5) says providers of high-risk systems, I think that's a glass of water, thank you very much, thank you. Article 10(5) says again that providers of high-risk systems may exceptionally process categories of personal data. That's under the General Data Protection Regulation and other EU instruments when it is strictly necessary for the purpose of ensuring bias detection and correction. This is a really important article. Really important, and we're very pleased to see it there. That's something we were calling for, because I think AI has a lot of potential, of course, and that's what this meeting is about, and the various working groups, about how to translate this principle into reality and how to mitigate against bias, which is a minefield in itself, and I know you're going to be looking at that in detail. When you're talking about personal data, you're talking about categories of sensitive data that we refer to in law, and they are defined in law, but they don't cover everything. So they're defined in law certain categories, but they don't cover everything in all areas of life. But this throws up many, many questions, though, including, of course, and I'm sure this is part of your discussion, how to handle proxies. Now, from our perspective, this is something that we've flagged in relation to the AI Act, and we have to see how the handling of proxies lands. And this is work we've done in the past, for example, on the use of large-scale IT systems in border management. So whilst you are not allowed to ask somebody their religion, for example, if you ask them their food choices when they get on a plane, if they tick halal or kosher, well, more than likely it might be indicating their religion. Also, of course, people's names. The name Mohammed, you're highly likely to be Muslim, etc. So all how we handle the use of proxies is really, really important here. And I think this is where many people are struggling, and this is where lawyers will also have to become more engaged in this regard. Now, very briefly, because I'm only focusing on the EU, because I come from the EU Agency for Fundamental Rights, the Council of Europe, and I know the next speaker, she's very much producing reports and working with the Council of Europe. The Council of Europe, of course, has its own legislation, a convention on data protection, privacy, you have soft law instruments, and you have an ad hoc committee on artificial intelligence. Now, this covers more countries than the EU. It's also important because once EU member states are signatory to this and member states are signatory to new law under the Council of Europe, they have to enact it. Also, the Fundamental Rights Agency was part of this Committee on Artificial Intelligence. We've been sitting in that committee as part of the EU delegation to the Council of Europe, which is a human rights body. And the text literally was agreed last Thursday at midnight on this treaty as it currently stands. So colleagues were in the room there as the ink dried, so to speak. It contains an article on non-discrimination. I'm not going to say more on that. But again, this is parallel instruments that exist. But I'm talking in the context of the EU and European countries here. So to move on, the Fundamental Rights Agency and our approach to artificial intelligence, what we're doing in that regard. Well, what we stressed from the outset when we were part of the high-level expert group on AI under the EU is the need for a rights-based approach. Of course, there's extensive policy development on AI, and the focus when you speak, of course, to people in industry and business is it's all about efficiency. It's still the mantra. And the phrase AI for good has been bandied about a lot. So in the early days of discussions when we entered them around 2017, and when you had a lot of lobbying for the industry, it was like, do not put the brakes on AI, do not come in with fundamental rights controls, because you'll stop us being efficient. Our competitors in China, the States will get ahead of us. So essentially, the Commission's papers and the thinking in the EU is about economic growth, essentially. And AI for good is placed in that concept, or human-centric AI. What it actually translates to, though, we have to see when the AI Act comes into being and we monitor what is going on. The early discussions also were dominated by philosophers and people talking about ethics. Ethics was the mainstream conversation there. Ethics are very good, but they have to be balanced with rights, because ethics, of course, are not enforceable in law. You can't have either or, they have to work together. So it's not an either-or discussion, but initially you can see the industry is very happy to say, well, we've got ethics going forward, you don't need law, we've got these laws, no need for it. Well, of course, the reality is now we have an act coming in the EU, Legal responses to AI are now mainstream, they're unavoidable, and within them they contain fundamental and human rights obligations. Fundamental rights is just the terminology the EU uses in this context. The rest of the world talks about human rights, but they're essentially the same thing that we're talking about. Also, what companies also said is increasingly they were beginning to get a bit nervous, and they said we need legal certainty when we're developing AI. They saw what had happened with the general data protection regulation, and if they got it wrong, they could end up with a court case. So the same is happening with AI. They say we need legal certainty to know if what we're doing is breaking the law or not. But why is that important? Not just to safeguard companies and that they don't face court cases, it's also very important for rights holders. So that when it goes wrong, AI, when you're discriminated against, you have the right to redress in law that something should be done for you. And that's AI for good too. So, talking about the need for an evidence-based approach, in the fundamental rights field, in the human rights field, there's a lot of generic and abstract discussions. Less so the evidence-based, and it means bringing together the computer scientists, the technical people, with people coming from a human rights, fundamental rights perspective. Lawyers are very good at putting up principles, but what it actually means to apply those principles in a granularity to help technical experts, data scientists, is something else. In terms of the fundamental rights impact of AI, I would argue that there's really scattered knowledge and a lack of really concrete evidence drilling down. And so I'd say the focus on concrete use cases to avoid abstract discussions in the context of applying fundamental rights is very much needed. So very briefly, this is some examples of FRA's publications that we've produced on artificial intelligence. And the first three you see there, the first 3 bullet points, these were very much focus papers that were desk research based. So we looked at discrimination in data-supported decision-making, data quality in AI, and at facial recognition technology uses by law enforcement. What helped a lot is the fact that the Fundamental Rights Agency has a long history of looking at discrimination using traditional tools like large population surveys. We conduct, for example, the largest LGBTI survey in the EU. We're talking thousands and thousands and thousands of people taking part. We undertake the largest survey on ethnic minority groups and immigrants in the EU. Why is this important to say? Because if you want to understand discrimination, you have to have good, robust data. And the kind of groups that we look at, there is not good, robust data in which to have tests of discrimination and bias. This is why we do these kind of surveys. So we brought the knowledge of these surveys also into our critique of artificial intelligence. So this is people's experience of discrimination in everyday life, employment, housing, education, for example. And then we decided that we should put our money where our mouth is, so to speak, and that we should actually begin to do research ourselves on AI. The last 3 bullet points there refer to these reports that we did, and I'm going to be speaking in the next slides to the report that we did called Getting the Future Right, AI and Fundamental Rights. We published it in 2020, and that involved in-depth interviews with developers and deployers of AI, about an hour-long interview per interviewee. And we were really trying to understand their conceptualization of fundamental rights applied to the tools they're developing and deploying. We didn't spoon feed them with a list of fundamental rights. We really had semi-structured questions to understand their comprehension. Then we've had other work on bias in algorithms, where basically we developed with computer scientists simulation case studies in 2 specific areas. Offensive speech detection was one, and predictive policing was another. And then a report from 2023 on online content moderation, where we were looking at that in different languages and not only looking at English, which is an important point to make. So again, reminding ourselves that when we did the interviews with our research with just under 100 developers and deployers of AI, this is the classic kind of quotes that we got from these people. It is mostly used to save time AI. when you have to go through a lot of material, and the most important is to deal with cases more efficiently. It's about making use of your workforce, the people who handle cases, as effectively as possible. And we interview people from areas like health, social assistance, also the police, for example. So it's a wide range of public and private sector actors. Not people who are a data protection officer in a big company, not those people, because they know what to say if you ask them questions about fundamental rights. This is to remind you a bit about the fundamental rights framework that predates the Artificial Intelligence Act. Within the context of the EU, you already have law that says you should not discriminate. It exists both online and offline, these laws, they have to be applied. You have the Charter of Fundamental Rights of the European Union that's been in existence for many years now. It applies in member states and to EU institutions when implementing EU law. There's a whole tranche of EU law that covers data protection and non-discrimination in different areas of life. So you have the AI Act, but already everybody has, the member states have to look at this, has to sign up to the Charter of Fundamental Rights of the EU, which has a specific article, Article 21, on non-discrimination and other articles. And you have international treaties and national and sector-specific laws. So not forgetting, there's a lot of legislation there that already exists that AI companies should be adherent to. So what I'm giving you now is a little bit of the taster of when we spoke to these developers and deployers of AI. When we spoke to them, the one right that they really all knew about was data protection because of GDPR. That's why it's traumatized a lot of people, that they know about it. Whether they know how to apply it, though, is another question. So, questions that arose during our discussions, they said, in terms of personal data use, when it is used and it isn't used, that was very unclear. Because they said, well, we're talking about large-scale aggregate data, so where's the personal data element? It doesn't apply. This is the kind of response you would get. They also didn't understand quite what the human review could be. If it's simply that if it's a large company, the data protection officer signs off on it, that's fine. A lot of questions like that. And this is a quote there on the right-hand side. We could take any number of quotes, but this is the typical one. There is the GDPR, but it does not give you specific rules. It gives principles, but it comes down to ethical issues and interpretation. Well, yes, but no, because if you get it really wrong, you end up with a case in court if you get it really wrong. Then equality and non-discrimination. Now, this is an area that people were a little aware of if you're talking about rights. So again, people who are not thinking about mitigating discrimination and bias. So people out there in the industry and the public sector. Interviewees were mostly convinced that their system does not discriminate. It's a bit like people say, you know, well, I know there's bullying in the school, but my child would never bully. Yeah, it's a good kid kind of thing. So I'm generalizing a lot, but also, some people knew about discrimination. They were aware of these big cases that had made the headlines, and that made them a little bit more conscious of course, the problems of facial recognition, classically, detection of people of different ethnicities, etc., etc. The question of proxies, and I raised that early, linked to protected characteristics in law, really didn't come up. It came up in the fringes of discussions. And the rights of specific groups was completely absent in the discussions with most people we spoke to. I give one example. In law, there is the specific right to the rights of the child, not only not to discriminate against the child, but ensuring that there is no harm in relation to children. But not a single interviewee voluntarily mentioned consideration of the rights of children when developing and deploying AI, which I think is somewhat worrying because we think of the kind of moral panic about AI and children. But at the same time, it's interesting that hardly anybody mentioned that. Some said, okay, we get discrimination maybe on the grounds of sex, we get it on the grounds to extent of ethnicity. But a lot of rights in terms of people with persons with disabilities wasn't there, religion wasn't there, and proxies is something else. Access to effective remedy. This is, of course, is a right in law. but there was a very limited awareness that people have the right to complain, and not many complaints were being received by companies. So the importance of transparency and explainability, huge concepts, which is there in the AI Act, really need to be made a reality for companies to be able to deal with this at a very basic level. I'll move on rather rapidly now because I'm conscious of the time. Impact assessments is something that, of course, is there. It's been there for many years with companies. But impact assessments also encompassing fundamental rights. Companies said that we need guidance on this. Now, once you have the AI Act, it will take quite some time before impact assessments are up to speed in relation to fundamental rights impact assessments. Most companies, they said, yes, we have an impact assessment, but essentially it was focusing on technical aspects. Does it work? Is it efficient? Is it doing what it said it should do on the tin, so to speak? And they don't know where to go to when it comes to overseeing AI systems. Is it just data protection authorities? Here's a list of all other fundamental rights that can be considered under EU laws. So it's not only discrimination and bias, there's a whole list of other rights that come into play if you have a fundamental rights impact assessment. This is just some of them, of which discrimination is only one, equality is only one. So right to asylum, using AI tools and discrimination, one obvious issue. Education, another obvious area. Freedom of assembly, if you're using facial recognition technology. The list is very long, and I don't have time to go into it now. So the use of AI should, as we now know, process data legally, not lead to unfair treatment, so it should be in line with legal obligations on non-discrimination, both direct and indirect discrimination. This is something that law has been dealing with for a long time, and case law too. Indirect discrimination, think about proxies, etc. And it should be contestable if something goes wrong. If you're discriminated against and an AI system is being used, you should be able to seek redress as a person who is discriminated against. So very, very quickly, some examples of the kind of research we've done, and I've just framed it very generally in biased algorithms, and I don't have the time to go into the findings, and we have our reports though that you can see. So what's the problem? There's, of course, we know many examples out there of biased algorithms in use, but there's a lack of knowledge and empirical evidence, like I said, including a thorough fundamental rights impact assessment beyond principal headlines. So there are many ongoing efforts to prevent and mitigate harms. It is a policy focus, and the projects that you're all working on are a very good example of that. What's bias? Of course, it depends on who you ask. It's difficult to pin down in law. Legal experts, as I said, tend not to refer to fairness. They prefer terms that can be tested in courts, discrimination, equality being the terms they would use. It might be unfair, but it might be legal, okay? So discrimination has a narrower concept, if you like, if you want to frame it like that. And bias relates to differential treatment of people based on protected characteristics in law. Like I said, some characteristics in law are protected. Article 21 on the Charter of Fundamental Rights is very important in the context of the EU, but not all areas. For example, if you feel discriminated against because of your body size or shape, that's not yet protected. There are a few exceptional cases out there. I think there was one in the Netherlands a few years ago. Bias, of course, needs to be looked at in context, and this is something that we struggle with and lawyers struggle with in particular in that regard. They like looking at it in context, and they tend to mistrust the use of statistics up to a certain point. Oftentimes, and don't quote me on this because they struggled with maths at school, so there's a big standoff that I see between lawyers. They said, I didn't like maths at school, and then you have statisticians and computer scientists come along and they try to communicate with each other. We've done work on the use of feedback loops. Feedback loops is something you'll be very familiar with, and the so-called runaway feedback loop. We looked at that with regard to data sets and algorithms we developed with computer scientists to look at predictive policing. In a nutshell, we very simply simulated predictive policing for different areas. We developed a machine learning model which can introduce bias. We looked at things like crime reporting rates, the observability of crime, the true crime distribution, so to speak, the police distribution in the area, a classic thing that people have been worried about going back to the 1970s or 80s in terms of over-policing certain communities in society, particularly ethnic minority communities. And of course, we found that the feedback loop, based on existing reported and observable crime data, soon got out of hand. It's quite simple, you're all aware of it, but for human rights lawyers to actually put this in a report was a kind of interesting thing for them to look at. Of course, most crime is hidden. Think of corporate crime, it's hidden. Think of domestic violence, it's hidden. So the feedback loop in terms of over-policing certain communities is very clear in that regard. We also looked at ethnic and religious bias in offensive speech detection. Again, we built algorithms using available social media data that we could access, and we looked at English, German, Italian, and we looked at 3 models in this regard: basic, more advanced, and highly advanced. And we did the classic natural language processing, a very basic looking at it to slightly more advanced, using invented text to test the models for detecting offensive hate speech. So the classic example here, and I'm reducing it somewhat, is if you say I am, you then insert the term Buddhist, Christian, Jewish, Muslim. Of course, depending on the model you're looking at, we found disproportionately I am Muslim had high prediction of offensiveness. I am Jewish also, less I am Christian, because Christian is of course a first name as well. So strong bias against Muslims and Jews in the models tested, and varying results across languages, models and ethnic groups. So this is something we all know about now, but I think from the fundamental rights perspective, we say these are protected characteristics in law, let's do the modelling too and see what it looks like. So obviously varying results, probably you can't read that very well, but again, this is in a model in English, the average there in orange, and the different green, blue, purple models that we tested. So lots of false positives around Muslim, gay, Jew, refugee, Nigerian in English. Then in German, looking at that, again, a lot of false positive as this being offensive in a very neutral statement, and looking at different statements. The term refugee, Muslim, foreigner, Roma, black person. And in Italian, Muslim, African, Jew, foreigner, Roma. So, you know, the patterns are there and we can see that. And you can have varying models, and depending on the model, we know that somehow you can have over-prediction or, on the other side, false negatives. And very briefly, of course, you bring gender into the mix as another variable. And then in Italian, I think we've got a few Italians here, so I'm not going to actually speak Italian at this point. Very mixed picture, depending on the model. Masculine nouns were slightly lower rated as offensive, and that's probably because of intersectionality working, so ethnicity plus you're female, okay? Could be, we would assume, a hypothesis. And of course, language is only one additional dimension of gender inequality. Gets more complicated in languages, of course, which have gendered nouns. In English, less so. That's why we have to work in different languages. So ways forward, my last 2 slides, you'll be glad to hear. So I've just really raced through some of the work we've been looking at, and it's in the reports that we've published. So this is kind of summing up some of the key takeaways from our research. What does FRA say? What does the Fundamental Rights Agency say? Well, to better understand and mitigate against bias and discrimination in AI, fairness, we have to test for bias repeatedly at all different stages. This is being introduced now, but bias and looking for discrimination can't be an afterthought. It has to be there upstream. And you have to provide guidance on sensitive data to be able to detect discrimination. So there needs to be a lot of discussions between computer scientists and human rights lawyers about what sensitive data does and does not encompass in law. You can go beyond that, of course, and I would say that's a very good thing to go beyond that too, to look for bias. assess ethnic and gender biases, and that's just 2 examples, especially in natural language processing. So much more needs to be done on that in a variety of languages. Consider all grounds of discrimination, as all of them are relevant. And the list, I didn't show you the list in Article 21 of the Charter of Fundamental Rights. It's a very long list there that now will have to apply to the AI Act. Strive for more language diversity, I keep saying that, and increase access to data for research and evidence-based oversight. This is something that really we have to make sure that people in universities doing independent research have access to data, so it's not only companies saying, no, you cannot do that, intellectual property rights, etc. Just as you have trusted flaggers in the Digital Services Act to look for offensive speech detection, you also need to have trusted researchers if you're going to talk about AI for good. Now, my final slide, in current research that the Fundamental Rights Agency is engaged in that also encompasses AI. We have work that we're doing on remote biometric identification for law enforcement, essentially mostly looking at facial recognition technology, but things like people's gait, how they walk as well in public spaces. So we're just testing with the police systems that they are using. This is a very sensitive area because, of course, in the AI Act, live facial recognition technology has been banned except for exceptional cases. There are a lot of exceptions in there. And we want to see how the police is doing this. And then high-risk AI, another project against selected member states and specifically focusing on specific use cases in different fields. So not looking just at policing, but looking at fields ranging from education to employment. So really testing the AI Act with respect to what would a fundamental rights impact assessment actually look like. And we have to work with the developers and deployers to understand the challenges that they face, because a lot of people, they don't want to do harm, but they really need help in understanding how they could potentially do harm, and we need to understand those challenges working with them. And then we have another project on the digitalization of justice. Desk research covers all member states, selected research in some EU member states. And we're looking at criminal and civil law applications of digitalization of justice, some of which include artificial intelligence. So this is the kind of work that we're doing, and I think I'll stop there. Thank you.
Thank you for the talk, very nice. I really liked also the timeline, so how the regulatory landscape evolved, I mean, from the robotics, etc., to AI Act and so on. I'm just wondering what is next? What can we expect? Is this the final, or what other changes to expect? And there are a lot of technological changes also.
Okay, in terms of law and policy, yeah? I mean, the AI Act, it will take a good couple of years for its actual implementation. So I think it's a very interesting time now also to talk about what impact assessment with respect to fundamental rights and mitigating against discrimination could mean. And I think to say that the European Commission will really need help in making that a reality. You've got EU elections coming up, we know about that. In terms of new EU law, I don't have a crystal ball. If I did, I would make a lot of money. But I think, yes, we're likely to see new legislation coming up. But you have the implementing acts under the AI Act, which means under the AI Act, there's going to be a lot of sub-part components of it that will have to be addressed, really. So I don't know. I think at the moment there'll be a huge amount of, we've done the AI Act, we had GDPR, let's not overdo it. There are some discussions now, for example, about the General Data Protection Regulation, about should we open it up again and reconsider some elements of it, because depending on what camp you're in, you might think it's been maybe too, how should I say, enthusiastically applied. Which can also stifle creative work for science, for research, for industry. So I think at the moment, because you've got the AI Act, which is landmark globally, you've got the Council of Europe's treaty, you've got different countries, we have to see what the States does or does not do in that regard, but they will have to apply the AI Act, of course, when they are working and deploying things within the EU. So I simply don't know. I think it will be a huge challenge to actually implement it effectively. And it takes a long time to implement, and for the courts then to be up to speed where we have a problem or where we don't have a problem. Within the AI Act, there is going to be a board, there's going to be an office, there's going to be a forum. The Fundamental Rights Agency is part of the standing bodies that will help with the oversight of the AI Act. We have to see. That's a non-answer, sorry.
Yes.
Hi, thank you so much. I'm Edward from Leiden University. I'm curious to know what's the role of FRA in the development of standards. There is a huge attention in the AI Act to develop those. So I'd like to know whether FRA or other institutions are really looking towards making standardization activities way more inclusive and I think fundamental right aware, because the industry always have other priorities. So that's the question.
Well, like I said, under the Act we are a permanent body under this forum that will be established. So we have a role to play there. But it's very much the European Commission under Directorate General Connect which should be looking at those standards. And of course there are parallel bodies that exist for standardization, product safety, you name it. And I think it's the linkages between these different bodies that have to be made, because the worst thing that any researcher or company need is who do they turn to, which standards do they have to comply by. So it's something that we will be looking at closely in terms of fundamental rights impact assessment, and to have something that people can really adopt. But it depends on whether you're looking at high-risk AI or other uses of AI. You will almost, it's not like one model fits all. So yes, that's something that others have been advocating, and we would advocate that too. I know that people want to have almost a simple checklist, but it won't be quite as easy as that. Yeah.
Hi, I'm Monique. I'm a PhD candidate in AI, and my PhD is in a computer science department, even though I'm a legal scholar from a human rights background. And I was really interested when you said about fairness, how this means differently for legal scholars. And one of the challenges working with AI, we have computer scientists, philosophers. So how to manage when talking about fundamental rights impact assessment, these differences in terminologies and understanding, because you need to create a common background. And as you said, fairness means something for computer scientists, for legal scholars, and for philosophers and ethicists. And a follow-up question from what I've heard here, how FRA is managing human rights washing? Because we see now that there are a lot of think tanks already advertising, auditing AI, developing and promoting the most ethical and human rights compliant, even though we don't have standards. So my question is these two challenges. Thank you.
So, going back to your second question, if you like, yes, greenwashing, if you call it...
Human rights washing.
Yeah, human rights washing within the AI community. Yes, you can go around any huge industry conference, as I sometimes do, and you can be sold a lot of tools that are not fit for purpose. And I think people struggle also from the public sector and the private sector of not knowing how to scrutinise that. So you do need some kind of certification going forwards maybe. So it's almost like I gave the analogy with the medicines agency or the chemicals agency, because if there are different standards out there, which one do you sign up to? So be wary of snake oil sellers, if you're familiar with that phrase in English. People who promise a lot, but it might not deliver. I think you're in a perfect place, that you're a human rights by background working with tech experts. I think that's a beautiful combination, honestly, and I think we need so much more of that. I think it's okay if we speak different languages, it's absolutely fine, but I would say because of the AI Act, if people who are learning in universities or going on to develop AI, they don't understand the law as well, they'll get in trouble. And the problem is even data protection people only partially understand aspects of it. So I think a lot of these like impact assessments that are being sold are very superficial, the ones that we've seen. Data protection, a little bit on discrimination, nothing else. So I'd say first thing, look at the Charter of Fundamental Rights of the EU, go through all the rights in the Charter. If you're focusing just on non-discrimination, I say just with lots of caveats, look at Article 21 and other articles in that regard and start working backwards with a very specific use case. Yeah.
Hello, thank you very much for your presentation. I work in AI ethics for a recruitment AI company, so everything speaks very much to my experience. I literally have a slide every time that says, look, there's non-discrimination law, there's human rights, and there's GDPR also talking about bias in automation, so I'm really happy to hear that I feel like I'm on the right track. Just wanted to share my experience. It is very difficult to align everyone in the company about what it means, to talk about ethics, to talk about fairness. I'm very aware that ethics is just like a bridge until the regulation is there, so I'm looking mostly at principles that are in a trustworthy AI, so that they are kind of conducive then to compliance. And I confirm that for AI developers, it is really not clear what fairness means. They look at accuracy, they see it as a trade-off with fairness. So what I'm trying to do all the time is like, okay, a product that doesn't work for a specific group is just not a good product. So try to look at it like that instead of, you know, getting lost in if we're trying to be too good and not make money. So yeah, and I just wanted to share. It's hard work to get everyone aligned and also to convince the most well-meaning that we don't need to come up with new things. So we don't need to outdo legislation, human rights, people that have been doing this for a long time. They're experts in their field. Yeah, I'm trying hard.
Well, good luck, I would say for that, yeah. But I think, I think the point you made is that we don't need to overdo it. I mean, it's good if you can go beyond human rights compliance, absolutely, with ethics. But I think what's really important is what you said in relation to, we have laws that exist already, and we have the big AI Act coming in now. So, you know, they need to, if they want to be risk averse, and most companies want to be risk averse, it's better to get it right upstream with that and keep testing at all different stages.
Okay, that apparently it was very interesting. I would also like to have one last question. Is the FRA looking into the differences into how fundamental rights are addressed and complied with across the member states?
We look at, in specific projects we do, for example, on the digitalization of justice, one of our most recent projects that's just kicked off. So we do classic desk research that will cover all the member states in respect to what the policy and law is on digitalization of justice and where it uses AI. So we'll have that kind of framing of it. But then we select specific member states, typically about 6, where we go in depth to actually, in that example, work with the judiciary in criminal and civil law, where they have then used AI in practice. So we don't have the resources to cover all member states with all use cases. It's always, we always put the caveats around it, which are typical of research, that what we're speaking to in that regard. Does that answer your question? Yeah.
So let's thank the speaker again.